law as a discipline is not limited to a technical exercise nor to an activity governed exclusively by laws. It is a profession that demands profound freedom of thought, commitment to the client, and a rejection of any external imposition that limits creativity and autonomy. In this article, we bridge the differences between legal systems, explore the philosophical foundations of individual freedom, and analyze how. The concept of reconnecting and confession illustrates the contrast between legal and spiritual cultures, as we reflect on the impact of leaders and collective dogmas on the autonomy of the lawyer, the philosophy of freedom, and the practice of law. Legal practice must prioritize the client's will over any personal belief or dogma. However, in many legal systems, this freedom is restricted by rules, traditions, or ideologies. In the Anglo-Saxon world, Protestant ethics and Calvinism have fostered a mindset where autonomy and individual responsibility prevail. This system, based on common law, offers a broad margin for the lawyer's creativity, allowing them to act as a true advocate for the client's interests. In contrast, in Latin systems, which are deeply influenced by Catholicism, the practice of law often operates under paternalistic structures that subordinate the freedom of both the client and the lawyer to collective norms. This framework reduces the capacity for innovation, imposing standard solutions instead of customized ones. For example, while an Anglo-Saxon lawyer can negotiate flexible and creative agreements in civil cases, in the Latin system, rigid regulations and predetermined procedures limit the ability to tailor solutions to the client's needs. Confession and being bound again. Contrast between spiritual and legal cultures. The concept of confession perfectly illustrates the difference between freedom and dependence. In the Protestant tradition, confession is made directly to God without the intervention of a priest as an intermediary. This act reinforces personal responsibility, emphasizing the direct relationship between the individual and the divine. In the legal field, this model inspires lawyers to act independently, focusing exclusively on the relationship with their client without external intermediaries dictating how they should conduct themselves. By contrast, in Catholicism, confession is made through a priest who acts as an intermediary between the individual and God. This model reflects a hierarchical and dependent structure, where the believer's freedom is subordinated to the authority of the religious institution. In Latin law, this dynamic translates into a dependence of the lawyer on the state or ethical system, limiting their ability to represent their client with full freedom. A lawyer influenced by this hierarchical mindset may feel compelled to act not in the client's best interest, but according to external rules or beliefs. For example, a Catholic lawyer might hesitate to defend a client whose morality contradicts their own values, whereas a Protestant lawyer free from this constraint would act solely in the interest of their client. The soma of the state and the cult of false leadership. In Aldous Huxley's Brave New World, soma is a narcotic that eliminates pain and personal responsibility, providing artificial happiness. This concept symbolizes the impact of state collectivism on the legal profession. In Latin systems, state paternalism and ethical norms restrict the lawyer's freedom, turning them into a technician subordinate to the system rather than an autonomous advocate. Additionally, the influence of politicians, artists, and public figures as false leaders represents a new form of secular religion where the masses place their trust and freedom in the hands of these idols. This phenomenon is particularly harmful in the legal profession, where the cult of personality can lead lawyers to act according to popular ideologies instead of focusing on their clients' interests. For example, a lawyer might feel pressured to avoid defending a controversial historical figure like Hitler out of fear of social repercussions, ignoring the need to guarantee a fair trial for their client. Jewish education and deism, models of freedom and responsibility. Jewish education, based on pillars such as work, knowledge, and personal responsibility, promotes a model of freedom and autonomy that inspires lawyers to think independently. The economic theory of thirds, which balances individual effort, social contribution, and spiritual growth, reinforces this vision of balance and self-determination. In deism, a philosophical movement that flourished during the Enlightenment, we find a similar approach. Thinkers like Jefferson and Voltaire promoted the idea of a creator God who grants individuals the freedom to guide their own lives. This model inspires lawyers to act as facilitators of their clients' autonomy, free from religious or ideological dogmas. Conclusion. Law as an instrument of freedom. Lawyering at its core must be an act of commitment to freedom and to self-determination. The lawyer cannot be a mere technician subordinated to collective norms or a defender of external ideologies. They must be an independent leader, guided by reason, the client's will, and an ethic based on individual freedom. Only a lawyer who adopts a libertarian philosophy inspired by models such as deism and Jewish education can guarantee effective and fair representation. In a world where ideological restrictions and the cult of leadership threaten to stifle personal autonomy, this approach not only benefits clients but also dignifies the profession, reaffirming its fundamental purpose as an instrument of justice and freedom. My name is Pedro Muñoz Lorite, a lawyer with international experience, having practiced in New York, London, and Spain. I currently lead my practice at B Abogados, where I promote a libertarian philosophy committed to the autonomy of my clients.